Major breaking news. We listened to almost 2 hours of oral argument this morning from the 7th Circuit Court of Appeals in Chicago addressing whether or not Illinois' various types of assault weapon bans are constitutional. It was a complete mess. We're clearly going to lose this, but let me give you the analysis when we get back. A lot to talk about. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on Amazon. All right, folks, major breaking news here. We listened to about 2 hours of oral argument today. In the 7th Circuit Court of Appeals, we listened to about 5 or 6 different lawyers arguing whether or not the various different forms of quote-unquote assault weapon bans, which are simply just bans on semi-automatic rifles, are unconstitutional under the Second Amendment, and relatedly, whether or not bans on magazines that hold more than 10 or 15 rounds are constitutional under the Second Amendment. Just to jog your memory, there was a series of federal cases brought in Illinois, thanks to various governmental divisions of Illinois, some involving the state of Illinois itself, some of which involves the county of Cook, which is Chicago, some of which involves cities like the city of Naperville and the like. There was really kind of 2 parallel paths here. You had some lawsuits challenging these laws in the Northern District of Illinois, which is the federal district courts based in and around Chicago. And then you had a series of court cases involving federal district courts in the southern part of Illinois, the Southern District of Illinois, including decisions by Judge Stephen McGlynn in favor of the Second Amendment. So the decisions in the Northern District of Illinois were against the Second Amendment. The decisions generally in the Southern District of Illinois were favorable for the Second Amendment and complying, as I see, with the Supreme Court precedent in the Second Amendment. It went to the 7th Circuit Court of Appeals, just to jog your memory, in a couple different cases, in a decision, really an order by Frank Easterbrook, who's terrible on the Second Amendment as a general matter, basically said that all the gun control laws in Illinois cannot be struck down yet. He denied and enjoined, I should say, or stayed, if you will, the injunction entered by Stephen McGlynn enjoining the Illinois state laws violative of the Second Amendment. There was an attempt to go to the U.S. Supreme Court on an emergency basis. When that was pending, Judge Easterbrook, I think, ran scared, and rushed out and entered an expedited briefing schedule, basically sending a message to the U.S. Supreme Court that we've got this, we're going to handle this really quick. There's no need for you, Supreme Court, to come in and spank us yet. And basically the Supreme Court let it slide, thinking that, the court is now going to, meaning the 7th Circuit Court of Appeals is going to handle this case quickly, which in fairness to them, they did. So today, after a series of briefs going back and forth by a bunch of different lawyers and law firms and different parties, we don't need to break that down in that level of detail for this purposes of this video, we had oral argument. Several different lawyers presented on both sides. I'm not going to really get into the specifics of all that, but what I'm going to do is give you the general bottom line here of the arguments on both sides. Each side was essentially allowed 45 minutes to argue in favor of the Second Amendment, arguing that these bans violated the Second Amendment. And then the other side, meaning the state parties, were given 45 minutes to argue that the bans on these magazines and these semi-automatic rifles, including the ban on sale of them and the purchase of them, so on, did not violate the Second Amendment. So, I'm going to make a long story short here. We had a 3-judge panel. We had Judge Frank Easterbrook, terrible on the Second Amendment. We had another judge, Judge Diane Wood, worse on the Second Amendment than Judge Easterbrook. And then we had a relatively new judge appointed to the bench by by President Donald Trump, Judge Michael Brennan. A little unclear record on the Second Amendment. I'm not sure he had any kind of history on this. So really, at the bottom line is this is a terrible panel for the Second Amendment. We're clearly going to lose this. That was my impression immediately once I saw this panel being announced. Judge Wood is so crazy bad on the Second Amendment that last week she actually entered a dissent in a case involving non-violent felons and whether or not they lost their Second Amendment rights for life. And she wrote a dissent from that, which was simply an order sending the case back down for further fact-finding information to the district courts. Nevertheless, she dissented, saying that obviously this law is constitutional. And in the context of that dissent, she literally talked about the in common use test, which of course is the standard for arms ban cases. Now, as to how Judge Wood thinks talking about the in common use test, a standard for arms ban cases, somehow is relevant to a felon Second Amendment nonviolent felon case is beyond me. But that's just how bad she is. And It's funny at the start. So I know we're going to lose this case right from the start. I knew it right once I saw this panel, but I said, well, let's keep an open mind and see what happens. Well, as this argument went on over the period of 2 hours, it became clear and clear to me, in my opinion, that the panel started to show their true colors. At the very beginning, I thought they were earnest and serious about trying to get this right. But it wasn't that long before the reality became obvious, and this panel's hostility, not just to the Second Amendment's right to keep and bear arms, but in particular to the United States Supreme Court's decision in, among other things, Heller and even Bruen. Now, the reason is, and we've talked about this on channel, because remember, it's my job to make you the smartest person in the room, and I don't care who else is in that room with you, by the way. I don't care what their credentials are. I'm going to try to make you the smarter than they are, and I think I can do it. And here's an example. So I've been explaining to you that two of the reasons, in my view, that Judge Wood and Judge Easterbrook are really almost bitter about the United States Supreme Court is they both, in their minds, thought they should be on it. Let's start with Judge Easterbrook. Judge Easterbrook thought he should be on the Supreme Court. He never got the nod. Frankly, and this is kind of funny, in part because Joe Biden, as a senator, publicly said he would never really support Judge Easterbrook to the Supreme Court, and he never got the nod. So in my view, he's always been kind of angry about the fact that he never got to go to the Supreme Court and remains an inferior court judge. Now, by the way, remember I talked to you about how under Article 3 of the U.S. Constitution, inferior judges are labeled exactly that? Well, guess what? Judge Easterbrook in today's argument actually admitted that indeed he used this language. He says, well, we're inferior courts and we have to follow the Supreme Court, but he's not going to do that, and I'll talk about that in 1 second. And then you have Judge Wood, who was appointed to the federal bench by President Clinton. She clearly had aspirations to go to the Supreme Court, but she never made it. I think Ginsburg and Kagan got there before her. So again, I think she wanted to be on the Supreme Court. And the reason why this is important, I'll tell you why this is important to your rights right now in this particular case. If you listen to this argument, rather than laser focus on the very clear question presented, which is that Heller said that handguns are protected arms because, among other things, they're in common use by Americans for lawful purposes. So the question is whether or not semi-automatic rifles like AR-15s and magazines hold more than 10 rounds or 15 rounds, are they in common use by Americans? And that's it. That's the only question. Instead, we literally sat there. And if you think this channel is geeky, we literally had to sit, meaning we, the royal we, by the way, I sat there by myself, but you get the point, the royal, the we. Everyone who listened had to sit there and listen to this argument about all these esoteric theoretical questions about Stinger missiles, grenades, machine guns, the gun that won the West, the death penalty, abortion and Dobbs. Yes, sounds like an academic seminar for a bunch of Mark Smith, Fort Box's Diner YouTubers. Yeah, that's exactly what it sounded like, a super geeky academic exercise. But here's the thing, this was not an academic exercise. This is a professional setting for professional lawyers arguing the meaning of the Second Amendment in the court of law, where an actual decision that's going to affect millions of people's lives will be decided. This is not an academic exercise where you can sit around and talk about what would he say in Plato's cave? And yet, if you watch this argument or listen to the argument, it really fell into that ultimately. So rather than focused on the real question whether or not the people in Illinois have a right to have these AR-15s and these magazines, the judges went off on a tangent. And let me tell you what was really going on here. And this is why I give you the backstory about how these judges think they should be on the Supreme Court. At the end of the day, this argument, which we're going to lose, by the way, I'll tell you how we're going to lose, and I'll tell you the pros and the cons of it. This argument became Judge Easterbrook and Judge Wood showing off, essentially, as if we were re-litigating the Heller case in 2008. They literally were pretending that Heller did not exist, that Bruen is the new law of the land, as if Heller is not the law, but you know that's not the case. Heller is clearly the law of the land, and Bruen simply reaffirms Heller and applies it in a new context. Heller was a gun ban case, meaning D.C. banned handguns, and Bruen was whether or not the right to bear arms means you have a right to carry guns outside the home for self-defense or other reason, right? Heller is still good law. Bruen reaffirmed it and actually quotes Heller favorably 80 times. Nevertheless, if you listen to this argument, these judges have no interest whatsoever, either because they're ignorant, which I kind of doubt because they have high IQs. I know Frank Easterbrook has a very high IQ. He comes out of the Law and Economics School, which is what I studied extensively in college. So I'm quite familiar with Frank Easterbrook. And he's no dumb guy. He's a very high-end IQ guy. And Judge Woods is no dummy either. Nevertheless, whether it's because they're ignorant about the Second Amendment and guns or they're feigning ignorance, I don't know. But if you listen to this argument, it's all about how do we apply this test? History is malleable. Don't know. We don't understand. This is circular. So really, at the end of the day, you had an entire discussion today during this oral argument was a critique and complaining session about the Supreme Court's decision in Heller. But none of this, of course, matters because their job, of course, is to apply Heller, whether they like it or not. And if I was doing the argument, I might have even said, it might have been a little bold, but I could be a little bold when I do my arguments, a little bit bolder than others. I might have said something like, look, if you're wondering whether or not grenades are protected by the Second Amendment, which you want to talk about, if you're wondering whether or not Stinger missiles are protected by the Second Amendment, if you're wondering whether or not machine guns are protected by the Second Amendment, then you know what? When we bring that case, we will talk about those issues. But until then, I am going to talk about whether or not semi-automatic rifles, as discussed by the United States Supreme Court case in Staples as being distinguishable from machine guns, by the way, and magazines, which are an essential component of modern-day firearms, whether or not they're protected under the in common use test by Heller. If you want to talk about these other academic exercises, I'm happy to do so, but this is not really the right setting since the decision has been made. And if you, panel, don't like the test, then I recommend that you get nominated and confirmed to the United States Supreme Court and redo the test yourself. But until then, it seems to me, if you want to talk about these esoteric topics, well, go do it somewhere else. Go to the Harvard or the Princeton Club and have a dialectic. But don't do it here in this courtroom where we're trying to decide this question. So a big part of this argument is about things that really were not relevant. It's all essentially about an attempt by these judges to relitigate Heller. But let me get down to some of the basic specifics now that I've given you the big picture. We're going to lose this case. The question is how we're going to lose this case. Remember, every opinion has this. There's a decision as to who wins the case and who loses the case, and then there's an opinion explaining the basis for it. Here's the weird part. Since we're going to lose this case either 3-0 or 2-1, I suspect 2-1, we should be cheering, as I see it, for the craziest possible opinion that we could possibly hope for from Judge Easterbrook and Judge Woods. The crazier they opine, the sillier stuff they say, the better it is for the Second Amendment movement. Because the more over the top they are, and they're going to be over the top, it's pretty clear, the more likely it is for the Supreme Court to do what it did in Caetano when the Massachusetts Supreme Court literally said that the only relevant arms protected are those in the 18th century. The crazier the decision from the Seventh Circuit becomes, the more likely it is the Supreme Court's going to step in and spank them quickly. So weirdly enough, we don't want to just lose this case because we're going to lose this case. I think we want to lose this case badly in a terribly written decision by Judge Wood and Judge Easterbrook. And I suspect that Judge Easterbrook and Judge Wood's egos are going to almost cause this to occur no matter what. That's my guess. Let's see what happens. They're going to try to thumb their nose at the Supreme Court and say, we're just reaffirming Friedman. We're going to basically analogize semi-automatic rifles to M16s. You've admitted that M16s can be banned. Semi-automatic rifles are just like M16s. We'll see if they stick to Staples or not. Probably they will. Maybe they won't. Who knows? But it's going to be a total train wreck decision. You just watch. It's going to be a few months before we see it, but that's the bottom line. Now, let me just get into some of the niceties, although frankly, I don't think we need to really get into this because the overall view is these judges are simply going to blow this up. They're not going to do anything favorable to the Second Amendment. It's just not going to happen. But I may as well flag a couple interesting points and a couple observations from this argument. One interesting thing is that Judge Easterbrook actually asked the state of Illinois a good question. He says, well, let me get this straight. So in the late 19th century, we had the gun that won the West, the Winchester, and are you saying that the government could ban the Winchester? And actually the state kind of messed this up because the state kind of said, well, you can kind of regulate it. You probably couldn't ban it. That's kind of what they said. And Easterbrook's like, really? Is that your answer? And actually, what's quite interesting is when the state did the rebuttal, they actually hurt themselves because they laser focused on the Winchester. When Judge Easterbrook asked about the Winchester rifle being the gun that won the West, he then went on and asked the state a very interesting question. He says, well, isn't the Winchester rifle, the one the West, isn't that really the same as today's AR-15? And the government did not have a good answer for that. And I think that's a great, great argument, although, frankly, it shouldn't matter with the in common use for lawful purposes. But I thought that was quite interesting that Easterbrook has at least given some thought to this, but he's still going to screw this up in my view. Nevertheless, he's clearly thought about some of these questions as he continues to attack the in common use test. There's a lot of discussion about these AR-15s being weapons of war. They basically really went all out, the state, to trying to say that these AR-15s are no different in any real respect than M16 fully automatic machine guns. In fact, early on, the state essentially says they're the exact same gun, these M16s and AR-15s, except, of course, the AR-15 is fully automatic, which, again, If I were arguing it on behalf of the Second Amendment people, I might have worked extra hard to work in a reference to the Staples case, because this U.S. Supreme Court precedent makes it clear that AR-15s are not the same as M16s, because AR-15s are semi-autos and commonly owned by Americans, unlike M16s. And again, the key is there's no need to try to win the fight today on machine guns. There's no need to win the fight today on grenades or Stinger missiles. All that's unnecessary. You need to keep bringing the argument back to, look, whether or not those are protected, I don't know, and that's not the question presented. All I do know is that if an arm is in common use, is protected. AR-15s in these magazines are in common use. Game over, period, full stop. We can talk about any of this other stuff if you want, but none of it matters. And if at some point there's a lawsuit brought over machine guns or Stinger missiles or whatever, fine, we'll litigate it then. But right now, that's not the issue, and we're going down tangents. Nevertheless, I think the lawyers on our side did a pretty good job in a very hostile environment trying to bring it back. Nevertheless, I suspect, I haven't looked at all the papers. I've looked at some of the papers. In this case, I think the papers for the pro-Second Amendment groups, from what I've skimmed through at least, look pretty strong. And a lot of these cases get decided on the papers, and oral argument doesn't make a huge difference. So we'll see if that's the case here. The other interesting thing, the Judge Wood, anti-gun judge, as best I can tell, clearly had no interest in doing the right thing under the Second Amendment, which is not surprising, as a Bill Clinton appointee to the federal bench who wanted to sit on the Supreme Court. So, that's just another Ruth Bader Ginsburg type. We're not going to get anything positive out of her. Remember, again, she's written terrible decisions in the past. She's going to write terrible decisions on the Second Amendment in the future. This is going to be one of them, although I think Judge Easterbrook will probably write this opinion because he's the chief judge, or he's the senior judge on this panel, so he's going to wind up writing it. That's my guess. We'll see what happens. Nevertheless, what's interesting is Judge Woods made an observation about that history is malleable. Remember I told you I was going to make the smartest person in the room? Here's the point. I told you that the anti-gunners were going to talk about history like, woo, history, narrative, storytelling. No. The U.S. Supreme Court said there's a particular type of history that is important, that's relevant, that's dispositive potentially. It is not airy-fairy history, narrative, storytelling about Betsy Ross and the flag. No. Particular type of history that's relevant to Second Amendment cases that the government bears the burden to come forward with and prove existed at the time of the founding and were enforced at the time of the founding are historical analog laws. This is not that hard. You don't need to be a historian to find out what was the law in 1791 involving a various aspect of firearms. And if you can't find it, too damn bad government, you lose. No excuses. You accuse me of a crime, for example, we go into a criminal court, the burden is on the government to show that I'm guilty beyond a reasonable doubt. If they cannot do that for any reason, the witnesses don't show up, they lose the evidence, they have a bad day in court, it doesn't matter. The government loses, I win as a free citizen. The same goes for the Second Amendment. The burden is on the government to show there is a historical analog law, a law, not airy-fairy history, a law that shows a traditional regulation, a traditional historical tradition of a particular type of regulation in American life regulating a particular aspect of firearms. And if the government cannot do that for any reason, they lose. Nevertheless, Judge Wood's saying the history is malleable. No, it's not. The question is, was there a law on the books? You don't need some historian to tell you the meaning of some, text. All you need to do is say, what laws are on the books? Can you find me a law in 1791 that bans any type of firearm? Yes or no? Counselor, yes or no? No? Well, then you lose. It's not rocket science. And the fact is that really irritated me about Judge Easterbrook and Judge Wood, both of whom, again, are high IQ, sharp people, are like, oh, this is so confusing and hard. BS. They know what they're doing. They're as smart, if not smarter than I am. They're sharp people, absolutely. They know what they're doing. Feigning ignorance in me like, this is too hard. Come on. You're not some high school kid, complaining about geometry. You're a high-end constitutional lawyer. You're at the height of the federal bar. You can figure this out. Follow Heller. Nevertheless, let's continue. Now, to point out that what comes up on this channel, often you see what happens in court, right? Because I'm pretty good at predicting where the anti-gunners are going to go. Guess what? Judge Easterbrook asked, and he did ask some tough questions of the state. Don't get me wrong. He was tougher on the state than Judge Woods was. He was tough. I don't think it's going to matter, but he definitely asked some tough questions. And one of the tough questions he asked the state of Illinois and their counsel was this. What is your best historical analog, counselor, to justify this gun ban here? What is the one thing you really want me to look at? And they came back and they said a couple of different things in the context of today's argument. But one of the big things they mentioned was gunpowder laws. Gunpowder laws that supposedly ban, having too much gunpowder in your home. Well, I have to give Judge Easterbrook credit here. He immediately says, no, that is a fire code regulation, isn't it, counselor? This is not a gun control regulation. This is about fire. So the state tried to say, so the state tried to come back and say, yeah, but what it is, it's trying to solve for the same problem. What it really is, it's like, fires kill a lot of people quickly, just like these guns can kill a lot of people quickly. So it's kind of the same thing. And it's pretty clear that Judge Easterbrook was not particularly buying that these fire code regulations are going to serve as historical analog to justify the gun ban. So I think that's a potentially good sign. They also talked about spring guns. But again, Judge Easterbrook is like, well, I don't need these trap gun, spring gun laws. This is really about protecting private property. And he's like, I'm not really quite sure I'm seeing that either. So the truth is, even though the in common use test is the test, and you don't need to talk about historical analogs at all, which we've talked about on this channel in the past, and we'll do it again. The fact is, there are no historical analogs that justify gun bans of commonly owned firearms or any commonly owned arms. So that's why the panel wanted to keep talking, and they talked extensively, and I kept rolling my eyes, about grenades. Well, can we ban grenades? And the answer is, I don't know, and I don't care, because this is not a grenades case. Can we ban Stinger missiles? Again, I don't know, and I don't care. This is not a Stinger missile case. And then, can you ban machine guns? Well, the Supreme Court has indicated yes in the Staples case and in Heller. But again, we're not talking about banning machine guns, so I don't need to answer this question. And again, if you panel want to relitigate Heller, get on the Supreme Court and do it. But until then, you are an inferior court under Article 3 of the U.S. Constitution, and you should behave as such. In fact, Judge Easterbrook specifically referred to himself as an inferior court judge, recognizing this dynamic between the Supreme Court and the Seventh Circuit Court of Appeals. Now, whether or not their egos will actually allow them to do the right thing, well, count me as a skeptic. Nevertheless, I can only tell you what should happen and what I think will happen, but only, as we've said before on this channel, the history of the future has yet to be written. Okay, there's only two more additional points I want to flag, and then we're going to wrap up. One is, one of the state's attorneys made a very interesting argument. They tried to draw an analogy to moderate self-defense. They say you don't just have the right to guns for self-defense, and you have to show you have a right to a gun for the purpose of moderate self-defense. They really were conflating two things here because, as you know, there is a rule in self-defense law that you have to use what's known as you cannot use excessive force. And what that means is if I see some 16-year-old kid trying to steal my $100 bicycle, I'm not allowed to pull out a firearm and kill him because he's stealing my bicycle, because that would not be disproportionate, or I should say that would not be proportionate response to the situation. That's kind of what they were trying to get at. That argument is really kind of a new argument the state's advancing. It cannot fly because they're conflating two things, which is a response to a self-defense situation with protecting arms. We can get into this in more detail maybe later, but that's not going to fly even with this panel. The other thing that I do think is actually quite good is that the state kept arguing about a single shooter using a firearm when he's an inexperienced shooter can kill all these people really quickly, but it wasn't that long before Judge Easterbrook frankly again, he's not a dumb guy. He came out and says, well, counselor, you're talking about, the dangers of these guns, but aren't you really just trying to slip in the back door? Means and scrutiny, meaning interest balancing, and we're not allowed to do that, are we? So how can we do that? How can we consider that these guns are good or bad or anything like that, where that seems to violate the clear mandate of the Supreme Court that says no means and scrutiny, no interest balancing. And yeah, I don't think the state had a good answer for that, because what they used to do in the front end, which is, hey, you got to do interest balancing, guns good, bad. Now they're trying to sneak it in the back end. But again, Judge Easterbrook seemed to think that was not allowed. Now, as to whether or not that's going to fly, I think they're still going to wind up doing it under a different name. But it was interesting that Judge Easterbrook specifically said that you can't weigh guns good, guns bad in the context of this fight. The last point I want to make is interesting is the state argument made really the exact same argument we saw in Heller in 2008. It's kind of amusing to hear this. I'll put a link to the argument if I can down below. I don't know if it's available yet, but I will try. But what's interesting is the state said, hey, we submitted all these experts that say that the better form of self-defense is handguns and shotguns and not rifles. Now, of course, as you know from my recent article, which I'll put a link to down below on the uncommon use test, I point out, and I did the research on this, which you can do yourself, it's all public. You can check out what was submitted in the amicus briefs and the party briefs in the Heller case in 2008. And there you see the anti-gun movement is saying that you can ban handguns because rifles and shotguns in 2007, 2008 are the preferred form of self-defense. So here, now we have the government defendants flipping the order saying, well, no, handguns are much better for self-defense than rifles. And that's exactly what they argued today in court, which is the absolute reverse of what they argued in Heller. But as I point out in my article, I talk all about and I point out by showing exact quotes from what was argued in Heller, that the exact same kind of public policy arguments about these modern firearms being dangerous, allowing one person to kill a bunch of people quickly, were the same exact arguments made in Heller that the Supreme Court rejected in adopting the uncommon use test to find that handguns cannot be banned. Specifically, remember, Heller was decided in 2008, and what occurred in the year of our Lord 2007? Well, one guy, a single shooter, a nutty shooter, in 2007 took multiple handguns, modern semi-automatic handguns, and shot up Virginia Tech and killed dozens of people right before the Heller case. And the Supreme Court says, look, we don't measure constitutional rights by how things can be abused or misused. We focus on the law abiding. That's how we do it. Just because some media organization might commit defamation against somebody, well, that doesn't mean you and I lose our right to free speech or the right to the free press. So again, it's very interesting that the same arguments being advanced in Heller in 2008 that the Supreme Court rejected and refusing to uphold a handgun ban are being brought on back by the same usual suspects in 2023 in the Seventh Circuit. Now, again, I think here we're going to lose this case. The question is, how badly will we lose the case? And will we lose the case in such a terrible, ridiculous way that the Supreme Court is going to look at this and do a summary addressing, meaning take a look at this case and do something to address it quickly on the grounds that this is just absurd, in the same way they did in the Caetano case to the Massachusetts Supreme Court, which went off the deep end involving the ban on quote-unquote 1970s based stun guns. So we'll see whether or not this panel in the Seventh Circuit does the same. I think there's a good chance they're going to, because I think they don't like the Second Amendment. I don't think they like the Supreme Court, and they don't like the Heller decision, and they don't like the Bruin decision. So I think they're going to try to show how smart they are and try to write the opinion they think the Supreme Court should have written. And I think that's probably just going to irritate the Supreme Court. But again, only time will tell. We'll see what happens. All right, folks, hope you learned a little bit something here today. Don't forget to subscribe to me if you're on Twitter at 4boxesdiner. And again, we'll talk to you soon here at the 4 Boxes Diner.
Orders up. Table 2A.